So next we have Mr. Joseph Dunne. He's an experienced trial attorney, another New York attorney. Not only do we have 3 American attorneys, I think we have 3 New York attorneys here, so, including me. I mean, you're not, but I am. So, and he is going to be free to
walk around
as a trial attorney is accustomed to doing.
I've always walked around, and if you find me wandering around, please forgive me. My name's Joe Dunne, and I represent blank. For 35 years of my life, that's basically what I did. I was part of an adversarial system trying to resolve disputes. Every day I went to court. I'm going to explain a little bit about the court system in the United States because it differs from that in Europe, and it differs from that in many of the Asian countries, including Korea. In the United States, we have a jury system. Makes it a remarkable system. And Professor Lay was talking a lot about things changing. Very often when we analyze Supreme Court cases, or you hear about the law in New York, or the law of the land, or the Supreme Court's doing this, or the Supreme Court's doing that, what's missed in that conversation is the fact that just like all the rights in the Constitution and the Bill of Rights were created by American citizens, what happens in the American court system is decided by American court system. And it's decided by American citizens. Often we don't hear that, and it's not part of the calculus that you hear. But when I go to court, and I went to court for over 35 years, basically resolving conflicts. Every day I went to court, it was me against somebody else. I wasn't going there to have an agreement. I was going there to have a fight, just like everybody else in the system. Our adversarial system came from trial by combat. That's not just a small term. That's literally what it means. When people used to have conflicts, they would pull out their swords and knights would kill each other. Some people would argue we haven't come that far from there, but actually we have. And now every day for the last 35 years, I go to court on numerous cases which I try to resolve. A lot of that involves trials. When you have a trial, you select a jury. So what does that mean to people not familiar with our system? When I go into the courtroom, I'll often be confronted with a panel just like this. There'll be 100 people in the room, and we don't know who's going to be on our jury. But that jury is picked from the neighborhood. If I'm in New York County, there's going to be people who live in New York County. If I'm in upstate New York, it's going to be picked from people from upstate New York. When people have problems with or concerns about the legal system, more of us have to be aware of the fact that the decisions of the legal system are based on the decisions of people in your community. And I think when we talk about peace or even world peace, peace to me is not a state of no activity where nothing is happening. Peace to me is an active system where you can go and resolve your disputes. We're never going to live in a world where we're not going to argue with anybody about anything. We argue with our spouses, our families, our bosses. We yell at the TV, okay? What we need is a system that we can go to, that we can trust, that's fair and impartial. And I think there's a lot to be considered with the adversary system. So what I'd like to do to people who aren't familiar with it is give it a little idea about when American lawyers go to court, what do they do, what do they try to achieve, and how close are they coming? So you're all potential jurors. What I would do is somebody would go to a box. And just like in the 1700s, they would put it in a tumbler, and they'd pick out 30 cards. No different than it was in the 1700s. Very similar. Out of those 30 cards, 30 people would come up, And then both people to the system get to ask those jurors, those potential jurors, questions to determine if they could be fair. Okay? That's an important concept. And what it shows is Americans like to be in control of their own life, about their own liberties, about everything to do with what's happening. So what happens is both sides pick a jury, and we sit down. We get to choose maybe 3 challenges. Otherwise, we ask people. We ask them questions about who are you, what are you about, what are your beliefs. There's a sense that somehow religion has no place in the courtroom. And I'd like to tell you from my experience, religion never comes up. You don't have to leave your religion at the courtroom. In fact, there are recent cases in the news within the last week or two where people have gone to court because they think their religion is being treated unfairly, or they didn't want to do something for somebody they didn't want to do it for. This is all part of the current American system. We may agree or disagree about the particular outcomes of a trial or about the appellate, the next level decisions, but we can't disagree with the fact that our system is a good system that provides people an ample opportunity to get justice. Both sides get to pick attorneys, both sides get to present evidence, but the jury decides what the facts are. 6 people from their own community get to tell you what they think about it. In the 35 years I've been doing this, I often agree, I often disagree, and sometimes I talk to the jurors not only before they get selected on the jury, but I talk to them after the trial is over. And I ask them questions. What did you think about this? What did you think about that? Now, in terms of human security and how to resolve problems between people, one of the points I've taken away from my last 35 years is, I may think I know about you. I may ask you questions and make assumptions about you. I may give you evidence, and I may look at you and you may look at me, and I may think I know what's going on. When I was young, I was right. 35 years later, I'm not so right. And I think that's one of the big points to take away from our legal system, that we have to understand that what we think about our adversaries, what we think about the people who have different views than us, a lot of it may be unintentional prejudice. Our insights may not be correct. And as a result, the people who are involved in negotiations, both one-on-one regarding peace matters, regarding human security, you have to be able to step back and realize that the people who you're so vehemently opposed to have a reason for what they say. These are, just like you, logical people. These are people who you don't understand, but these are people who have reasons for what they think. After 35 years, I've heard a lot of different stories. When I was younger, like I said, I thought I was always right about everything. As I'm older and more seasoned, I can see the shading and I can see the gray of different arguments and different viewpoints. We need, as a world, to do more of that. We have our enemies, just like they had in the 1800s and the 1700s. We tend to characterize our enemies. I would tell you that I don't think the characterizations help us. They don't move us forward. We have to spend more time understanding. And even when we think we understand, in my experience, we often don't. And sometimes when we get the results that we get, we can, as attorneys, as human beings, as participants in an adversary system, make up excuses or try to explain what happened in sort of a way that's less than perfect, less than honest. So when I originally wrote my paper, coming here today, I thought I would talk about all these other topics. When I looked at, and through the last 3 days, I realized what I had to offer was, how do we solve human security issues? What do I know about how to actually deal with problems? And what I have to offer is the problems that we create, the problems that we're part of, we are part of the making. Those of us who think we're only the good guys and that everything we say is right may not be the case. And I'd ask you all to sort of reflect on that, whoever you are and whatever it is you're doing. Once the jury is selected, the case is presented. Both sides get to present their case, both sides get to put in evidence, and both sides get to do opening and closing arguments. Then you go into a jury room. And this is another important part that the adversary system has to offer anybody in any sort of alternate dispute resolution, any sort of problem or area where you're at odds with somebody else. When that jury goes into the jury room, they were told by the judge throughout the trial, don't make a decision. Don't talk to each other. Don't do it. The first time you start discussing it should be when that door closes and you're all in the room for the first time. These people don't know each other, by definition. They don't know the parties. They never knew the issues beforehand. In fact, a lot of them are very limited into, in terms of knowledge of the whole area. That's the whole point. In addition to picking probably 100 juries and having as many trials and doing arbitrations and mediations, I've also had the luck to serve as a juror on 4 occasions. The last occasion, I was a foreman in a murder trial. It was a murder trial in Brooklyn. I lived in Brooklyn at the time. Happened to be on a block that I lived growing up. But my experience from being a juror in a trial really informed me about what works in life and what doesn't work. And what works is people working together, people being honest, people doing their job. When those people are picked for jurors and they go back to deliberate in a jury room, they do just that. In my experience in the juries that I've been on, people take their responsibilities very serious. And just when we're negotiating with people, when we're at odds with people, we should respect the fact that they also have a job to do, that they're dedicated to their job, that even though we don't agree with what they're saying, they have motivations, and their motivations are just as important to them as our motivations are to us. So I think what I'm saying throughout this is that after 35 years of solving problems on a daily basis, you can do it, but you have to leave things open to question. You have to doubt yourself, you have to doubt your instincts, you have to doubt what you know, and you have to doubt the assumptions that you don't even know you have. Life is like a chess game. If you only think in terms of what your particular moves are, you're not going to do well. Luckily, we have organizations like the United Nations and places like that that actually do a very good job. However, I think that the adversary system and the inclusion of everyday people adds to our knowledge, adds and gives a level which I think is often missing in larger organizations. When you complain about the court system this and the court system that, I don't see a court, I see 6 people. I see 6 people from the same community. I see 6 people actually attempting to do the job that they were told to do. It's a remarkable thing. We should try to emulate that idea. We should try to emulate that ideal. And going forward, we should take into consideration some of the very aspects which make the adversary system so successful. Today in the United States, there are thousands of people bringing many thousands of cases, going to court. And what those people are doing is they're saying, my rights were violated. I need justice for this. I need justice for that. The system works. It gives them justice. It gives them an opportunity to go to court. And while it's not perfect, as Winston Churchill once said, there is no next best thing. That's what we have, and I recommend it to all of you. Thank you.